Thanks so much for joining us today. This is the third presentation that we're doing in an 8-week series put on by the Van Winkle Law Firm's business group, and the second week in a row that you've been lucky enough to hear from Ryan and I. As we mentioned last week, Ryan is based in our Asheville office and I'm based in our Hendersonville office, and we're both part of the firm's business law group. If you've missed any of our prior presentations in this series or the 16-part series put on by our trust and estate colleagues in late 2020, you can access those by going to our Facebook page, which hopefully you're watching us on now, or our YouTube channel. Finally, as our colleagues have all mentioned, our presentation is not intended to be legal advice and is based on our experiences with general North Carolina and federal law. You should consult an attorney with specific legal questions. If you don't already have an attorney, feel free to call us and we're happy to assist you or point you in the right direction. So without all that out of the way, today we are going to talk about buying and selling businesses, and whether this is the first time or the 100th time you have bought or sold a business, we hope that you leave our presentation having learned something new. And Ryan's going to take over now.
Thank you very much, Meredith. Appreciate everybody joining again, even after last week, if you watched last week. Hopefully we were good enough to get people to come back. So yeah, I think it's the kind of thing that we run into quite frequently in our practice, where we're running into a first-time seller in particular. Buyers sometimes are first time, and sometimes they've done it more times than they can count. But in most cases, sellers are the ones who are facing a transaction with their business for the first time. And there's an analogy that can be helpful when you're talking about buying or selling a business, to kind of grasp what all the concerns are and make it more familiar with folks who haven't sold their business before. And so the analogy that sometimes used is the process of buying or selling a used car, which, no offense to your business, but there are a lot of similarities between your business and a used car. So we do use that pretty frequently as kind of a jumping off point for a lot of our conversations. But even if you're going into the first time as a seller or as a buyer, or you're doing it multiple times, one thing that is kind of across the board is that no one comes into a transaction in most cases on their own with absolutely no background or no preconceived notions about how a transaction with their business is going to go. In most cases, folks, even if they're selling for the first time, have talked with a friend or a colleague or a business partner or an attorney, CPA, somebody, financial advisor, who has some experience with a transaction for a business. And so lots of times folks will come into a conversation with somebody like me or Meredith, and they'll have some idea loosely of what's involved in the process of buying or selling a business. And it's not always, the right thing they should come into that conversation with, but it always makes those initial conversations very interesting. One thing that we kind of start off with is talking about who all is going to be involved in the process. And quite frankly, it may be none of the people I'm about to talk about. In most cases, it's at least one of the people I'm about to talk about. But depending on the size of your business, the complexity of the transaction, quite frankly, the dollars and cents involved, you can have any number of people who are involved in the business transaction process. And obviously, you as the owner of the business, or if you're watching as a member of the C-suite of a business, or as a majority shareholder in a business that is looking to buy or sell, you're going to be involved because your opinion, your vote matters. And you may even be involved in some of the processes involved in the transaction that Meredith will touch on a little bit later in the diligence part. But in addition to the folks who are involved at the company level, in most cases, there's at least somebody looking at the legal perspective of the transaction. There's somebody looking at the tax side of the transaction. And there's oftentimes somebody who's looking at the transaction from a financial planning or estate planning or some kind of long-term goal position. And so the way that you see that usually shake out is that in most cases, if you've got a business that's doing any serious amount of revenue, you're going to have either someone in-house or that you contract with who's performing some kind of accounting function. And so in lots of cases, that's a CPA. And if you're doing enough business, it should be somebody who's a CPA who can help advise based on their experience with the business, how you might want to structure your transaction. They might also be able to consult with you during the due diligence process when you're getting out things like tax returns and financial reports, P&Ls, and profits and loss statements, balance sheets, things like that. We'll either start with your internal financial person or tax person, or it can be moved out to somebody like an outside CPA. So that's one person that's usually involved, even in small deals. Somebody is looking at it from that perspective. And if you don't have somebody who's familiar enough with your books, tax, and financial picture to make it through the due diligence process that Meredith's going to talk about, you need to engage somebody like that quickly. At the end of the day, a transaction is about money, and if you're going to be receiving money as a seller or you're going to be paying out as a buyer, you want to make sure that you're maximizing the tax impact of that transaction. And somebody like a CPA can be very helpful from that perspective. So in most deals, there's a CPA involved. In almost as many deals, there's an attorney involved, at least on your side, and in most cases on the other side as well. If you're on the buyer side, an attorney is going to help you with the initial proposal for a structure on a transaction, whether it's going to be an asset or a stock purchase, for instance, or if you're going to pay everything at closing, or you're going to pay things over time in order to buy the business. And on the seller side, the attorney is going to perform primary function of making sure that you achieve your goals. You're signing up for what you thought you were signing up for when it comes to the deal. And also, lots of times you spend a lot of time with your attorney on the seller side, trying to make sure that you don't have to look over your shoulder when it comes to after the deal, clawbacks potentially in the purchase price for indemnity obligations and some other things we'll get into a little bit later. So in most cases, you've got a CPA, and in almost every case, you've got attorneys involved on both sides. And beyond that, as the dollars start to get higher, start looking at, going from a small market to a mid-market deal, you start to see other folks who might be involved, and those include people like investment advisors. If you're selling a closely held business and it's of any significant size, you probably already have somebody involved as an investment advisor, whether it's for a company office or a family office or for a company itself. And so lots of times you'll see financial advisors. They can help you with preparing the company for sale, sometimes finding a buyer. They can give you advice on when to sell in the context of your greater estate plan, or where you and your fellow shareholders are in their respective careers. And they can also help you decide what to do with the money if you're selling after. That's part of why you're selling. You're looking for a liquidation event, and investment advisors can be really helpful immediately after the transaction, as well as weighing in on how a transaction goes through. In addition to that, whether it's a small or a large deal, lots of times you'll see a couple other professionals involved as well. And those include a broker and an insurance agent or insurance advisor, broker in some way. On the insurance side, it's more about operations. It's about, if you're on the buyer side, making sure that you are, you know what you're getting into from a liability and risk standpoint, making sure you're setting yourself up to hit the ground running day one with the kind of liability protections that you need. And on the broker side, that's where it all starts. I'm leaving it to the end, but it's really because it applies in every deal. You're going to have to find a buyer, or you're going to have to find a seller. It's not that frequent that you just wake up one day and all of a sudden someone is at your doorstep saying, I want to buy your business. In most cases, you've got to locate that person, and they've got to locate you, or you just happen to run into each other at a coffee shop, which doesn't really happen anymore in our current times. So brokers can be very valuable individuals when it comes to doing a deal. They can, in most cases, they exercise a network that they have to try to locate folks who might be interested in the size of business you might be selling, or the size of business that you're looking for. And so you enter into an agreement with them. Oftentimes it's exclusive, with the end result being they're going to find a partner for your deal for you. Hopefully somebody that can not only purchase your business, but if you're on the sell side, and make it successful after closing, but also get somebody who's willing to work with you so that the structure works out for you. So all these other advisors that you might have, depending on the size of your deal and what your goals are, the broker can help you hopefully find a buyer or a seller on the other side who's willing to be flexible in that respect as well. So you can have a lot of people involved, and of course you're going to have the uninvited advice as well of people who have done it before, and friends and family and all of that. And it can be very helpful, but it can also be very confusing. And so knowing what each of what those individuals might do, what kind of services they provide, can be very helpful. And it's something that, especially on the broker side, locating someone to do a deal with, and the CPA and attorney side, you want to make sure you get people involved in the deal pretty early on. This is a common question that we get, when should I get an attorney involved, for instance? And usually my answer is, if you're asking that question, it's probably time to have an initial conversation, honestly. And Meredith's going to talk a little bit about what the components of a deal look like, but really through each one of those that she's going to talk about, you should have already had a conversation with an attorney or CPA before you get putting pen to paper or electronic pen to electronic paper these days, because even in instances where things might say that they're non-binding, or maybe things that don't tie the deal up entirely by their nature, they can have significant impacts on the way a negotiation goes, the timing of a transaction, whether you end up being able to do a deal that fulfills all of your goals. So I think it's probably helpful, now that we've kind of got a set of who the roster is, with broker, CPA, attorney, investment advisor, insurance agent, and other folks here and there. It's probably helpful, Meredith, for you to talk about what goes into a deal and what the mechanics are, what they should be looking out for.
Great. So I like that Ryan just referred to components, because I think these are all separate components, but they may be part of the same stage. So we've broken this down, sort of a deal, into 6 different components. There are oftentimes a lot of terms that you're going to hear floating around when we talk about a deal. So I'm going to use some acronyms, but also tell you what they mean as we get into that. So our basic components here, we're going to start with an NDA, which is a non-disclosure agreement. We are then going to move to an LOI, a letter of intent. Now, Ryan's going to talk to you a little bit more about an NDA in a minute, but this is a place where the 2 components might be combined. You may have the NDA and the LOI sort of being negotiated at the same time, but I think Ryan's going to give you a caution about making sure that the LOI does not come before the NDA. So we'll get to that in a minute. The next sort of component that we're going to talk about is the purchase agreement. It's important to understand that the purchase agreement is going to be different depending on how the deal is structured. So if you're a company that has stock, there could be a stock purchase agreement. If you are an LLC and you've got membership interests, there could be a membership interest purchase agreement. If the buyer does not want to take on all of the liabilities associated with the company and wants to structure the deal as an asset purchase, you could have an asset purchase agreement. So there are sort of different categories of agreements, but the purchase agreement itself is another component of the deal as we're moving through things. Now, when we talk about components that can be combined in a stage, sometimes we have the purchase agreement being combined with closing, and sometimes closing is separate. So if we've got a purchase agreement that's signed and then there's a gap in between the time before we actually close the deal, during that gap, that's called the diligence period. So if we do a combined sign and close, we have to do diligence before we do all that. But if there's a gap in between, the diligence period is a separate component. And we'll talk about that more in a few minutes. And then the big piece here we want to make sure to talk about is that after closing, you're not done. That's the exciting part, right? You've bought or sold your business, but there are post-closing obligations. So we wanted to give you a big picture view of what are the different components or stages of a deal before we talk about each of them a little bit more. So it's probably helpful, Ryan, for you to talk about NDAs now, if you don't mind.
Thank you. Yeah, so an NDA, non-disclosure agreement, confidentiality agreement, it goes by a lot of names, but at the end of the day, what it means is keep your mouth shut about what you're about to hear. We didn't make anybody sign one before listening to this, although in retrospect, maybe we should have. We could have protected our value a little bit more. But anyway, this is where a deal should start. From a buyer's perspective, an NDA is a necessary obstacle to get over in order to get to the good stuff. From a seller's perspective, it's a critical part of the deal. When you're on the sales side, unless you walk into a deal where all of the key pieces are already decided, which I can go ahead and tell you never happens, you're going to want to maintain as much leverage as you can going into negotiations about what comes next, which is the letter of intent, and the main business points in a transaction. So in addition to maintaining leverage, you also want to protect all of your hard work, all the things that you've put into the business that you're about to either put on the market or you've just put on the market. And one way to do that, a commonly accepted way to do that, is to give an interested party, a potential buyer, a broker, if you're just starting off with a broker, giving them a non-disclosure agreement to sign. And the non-disclosure agreement, or NDA, has many common components, and it's not infrequent that we find that leads clients to determine that they want to pull one off of the internet and just sign it and send it along. And, you know, a broken clock is right twice a day. But I would suggest going to an attorney to talk about the NDA, because depending on your business, there may be different things that you're concerned about. It may be that you're concerned about trade secrets. It may be that you're concerned about simply the financials, or if you're talking about a situation where you're a retailer, margins, that's what you're concerned about. These are the things that you're really concerned about giving to a buyer who's potentially a competitor in your industry already, and making sure that the information that you give to them to help them come to a conclusion about whether they want to do a deal with you and how they want to do that deal with you, that when you give them that information, they're going to use it for that purpose only. And they're not going to use it for any other purpose, whether it's after the deal has fallen apart and they want to sell that information to another competitor, or they want to actually use it in order to compete with you in the market. So the NDA is all about protecting what the seller has to share with the buyer in order to get a deal done. And in many cases, it can go as far as also keeping confidential the fact that the seller and the buyer are even talking to begin with. And that can be very valuable. A buyer is probably going to prefer that to a seller in most cases, although there are instances where a seller would prefer to have that included in the NDA as well. And the reason for that is a buyer doesn't want to start a bidding process that they're going to have to outdo another bidder. They'd like to keep things confidential so that they can get the terms that they would prefer without having market pressures apply so openly in the absence of that kind of agreement. So those are the main components of an NDA, and that's kind of the point of it. And if you go directly into a letter of intent, or you go directly into a purchase agreement negotiation, on the seller side in particular, you risk having information available to another party who's got no duty to keep it quiet and no duty to use it only for the purpose that you intend them to do it. So an NDA is a very important part to start off the process from a documentation standpoint.
So if you have started talking to somebody about an LOI and you've not done an NDA separately, we'll talk about, in an LOI, a letter of intent, you can wrap some of that confidentiality stuff up in there. But we would advise do the NDA first. So once you've gotten to that letter of intent stage, the thing that we really want to focus on here is that LOIs are not binding agreements in and of themselves, but certain terms in a letter of intent are binding. So a lot of times when we're providing advice to clients about how to negotiate an LOI, there's a lot of discussion about what to negotiate now and what can wait and be negotiated later in a purchase agreement. There are certain terms that you do want to go ahead and negotiate. For example, we were on a call yesterday that a client was very concerned about who was going to be obligated to enter into restrictive covenants and how long were they going to last. For them, this was a point on which they would walk away from the deal if this point could not be agreed upon. So it's something we did include in their LOI. Generally, you may not want to get that specific. So it's really important to talk about the facts for your situation and which terms you want to include in your LOI. And I think Ryan has already mentioned this earlier, but also during our contracts presentation, we talked about when to bring an attorney in. And a lot of folks do not bring attorneys in at the letter of intent stage. Our point during the contracts presentation, and hopefully you're getting that again today, is that if you bring us in earlier, it may actually make our involvement be less for you in the long run. After you do the LOI, again, we want to talk about the purchase agreement. I'm going to turn that back over to Ryan.
Yeah, so a purchase agreement can take many forms, as Meredith pointed out earlier. You know, depending on whether the target company is a corporation or an LLC or a partnership, can go by many different names. And in addition to that, depending on the structure of the deal that's being contemplated, you may need a merger agreement instead of a purchase agreement, or a contribution agreement instead of an asset purchase agreement. There are a lot of different ways to structure a deal. And what you end up with when it comes to a definitive agreement depends on what the goals of the two parties are, what you're able to negotiate in the letter of intent, and really what the substance of the transaction is at the end of the day. I think that we could sit here for a really long time and talk about the different types of purchase agreements and how complicated they can be, but I don't really want to get into that. I think there are two big kind of buckets that most of these transactions fall into. One is an equity purchase, and one is an asset purchase. And in the equity purchase, so that's a stock purchase agreement or a membership interest purchase agreement, the two most common forms of that. In a stock purchase, you're not actually selling, you know, the forklift that you've got on the manufacturing floor. Instead, you're selling your interest in the business that owns that forklift and the rest of the assets in the company. So it's a little bit like you're selling your company rather than you're selling the pieces of your company. And in a lot of instances, a buyer may not particularly be excited about an equity transaction. There are a lot of reasons for that. Most of them are tax and liability related, which are outside the scope of this context. But in most cases, you'll find that a seller is more likely to be interested in a stock deal than a buyer is, with obviously some exceptions. The other big type of transaction is an asset purchase agreement, an asset sale, and that's where you're actually selling the forklift and everything else that you've got. And also, it may be things that you're selling that you don't necessarily think are assets, or you wouldn't think about as classic assets. You may be selling your personal goodwill in the business as the seller. You may be selling corporate goodwill. If you want to talk about the difference between those two things, definitely send us a comment, because that's another thing that could take forever. But the main difference there is that in a stock purchase, you're selling your stock in the company or your membership interest in the company. In an asset purchase agreement, you're selling the actual assets. And an asset purchase can also be used for other instances where maybe you're not selling your entire business. You may be selling a division of your business, in which case, you know, you can structure it as an equity deal, but it requires some gymnastics before you get to that point. Or you can actually just section off divisions or assets that are part of a division and do it that way. And the differences can be significant and lengthy between those two general types of structures. There are tax reasons to do each on the buyer and the seller side, and there are liability reasons to do each on the buyer and the seller side. Both of those are probably outside of the scope of where we are, but those are the two main ones. And as far as the components that go into those two different types of main of purchase agreements, there are a lot of similarities. Obviously, there's going to be the business deal. We're always going to try to work in a bunch of defined terms that take up a lot of pages, but they all have a point. You're always going to have the business deal. This is how much money is being paid for this, for whatever is being purchased. But then you're going to have sections that talk about how the seller has run their business, how the seller has owned the business, what kind of debts are out there, what kind of liabilities are out there, and having the seller make a lot of promises about how they've run their business. Or to bring it back to the car analogy, how they've driven their car. Have they been a wild, reckless, aggressive driver, or have they been one of those safe drivers you see on the car insurance commercials on TV? It can really come down to the business too, and what you're able to say about how you've been running your business in the representations and warranties section of your purchase agreement can increase the amount of purchase price you're going to get. It can decrease the amount of liability you have after closing. So that's a very important section that ties into the due diligence period that Meredith's about to talk about. And so, you've got your business part of the purchase agreement. You've got your reps and warranties from the seller and the buyer, but on a more limited basis. And then there's always a section about, well, what happens if something goes wrong? And that's usually in the remedies section, where there are sections about indemnity, where a seller might be promising to make a buyer good if something goes wrong from a monetary standpoint. And there may be other things that follow after closing that will be tied up at the end of that purchase agreement. So there are a lot of similarities, but the impacts of the differences in those agreements and those different structures can be long and profound, and they can be very, very helpful or hurtful depending on whether you get what you want out of those. So maybe to talk a little bit more about what goes into that reps and warranties section and process behind it, Meredith, if you could talk about the diligence period.
Yeah, great. And I know we are starting to run kind of short on time. So even though diligence could be talked about a whole lot, we'll be pretty brief talking about the diligence period. We just want to focus on this because this is actually the most labor intensive part of the deal process generally. So as a buyer, diligence is your opportunity to thoroughly investigate seller's business. You can ask lots of questions, make lots of requests for information. There are all kinds of categories of things that you're going to want to look at, starting with the business's operations, financial performance, legal and tax compliance. But then you're going to also want to ask things about customer contracts, intellectual property, other assets. So all of these questions are intended for you to get an idea of the financial risk involved, not only in purchasing, but in continuing to operate the business. As a seller, be prepared. You're going to be asked about every material part of your business. You could, if you're thinking that you're going to sell sometime in the next few years, go ahead and begin preparing responses and gathering some of the information that you'll be asked to provide. Some of the topics that I mentioned before that a buyer will ask you about are a good place to start. You're also going to be asked for, information about your employee benefits, your insurance, things like that. So having that documentation in order now will really help you. As seller, part of this diligence period is populating disclosure schedules in the purchase agreement. So all of that information, will need to be organized and set forth in a way that you can be responsive to any request for information. Once you get through the diligence period, we're at the fun part, right?
Yeah, and it used to be really fun. Back when we could all see each other and before the internet happened, everybody would go to a table and they would pop a bottle of champagne, cash checks, and congratulate one another on a deal well done. And that's the closing. And the closing oftentimes is still characterized as happening at an attorney's office in a deal document, but in reality these days, unless there's a need for that to happen, it all happens with the push of a button, which is much less exciting until the funds hit the seller's bank account and the buyer gets the keys to the business. The closing depends on a lot of things happening, going well, communication between the seller and buyer and their respective counsels. And in order to make sure you get to closing and you don't have an issue, there are a lot of things you have to address up front as you go through the process, which include making sure you're getting all of the right approvals from the relevant stakeholders, which are stockholders in a corporation or the board of directors as they're directing the deal, as well as if you've got a business that depends on permits or licenses or long-term contracts that are being assigned in the deal, you oftentimes have to get consent from third parties in order to get to closing in a way that's not going to breach one of those agreements. That's a key part of the business value that's being transferred. One thing that we run into a lot these days are PPP loans, which is always fun to talk about. But fortunately, there's a great mechanism set up for those of you who are getting second PPP loans and may be looking at a transaction in the near future. There are mechanisms set up now to escrow an amount of the PPP fund where you can do a deal even if you've got the PPP loan out. So that's just one example of one of the types of consent that you might need to get. But once you're done, and if you had your own champagne, fine, and everybody's very excited about the transaction having happened, there are a few loose ends, and so Meredith can talk about the post-closing matters.
Great. So Ryan's already mentioned escrow. So there's a couple of things that play into that. And escrow is where a certain amount of money is held back for a certain period. So PPP loans are one place that we're seeing some language related to escrowing. But indemnity obligations are another place that we think about escrow. Those obligations are not usually limited to the escrowed amount, but can be. So taking stock of and sort of monitoring indemnity obligations and then compliance with any restrictive covenants post closing are things that you should be paying attention to. In addition, just thinking about sort of, hey, what happens after closing? There might be the need for a transition services agreement where you've got certain services like payroll or employee benefits that need to be continued to be provided for a certain amount of time. And then part of the purchase agreement may be an earnout. So that's future contingent consideration based on achievement of certain milestones in the future. So like we said, closing is the big fun part, but there is certainly a lot of stuff that happens post closing that you should pay attention to also.
And I just want to say thank you guys for bearing with us for those last 2 minutes as we went over time. As you can tell, we're trying to pack a lot into a small amount of time. But we appreciate you joining us and hope you will come back next week at the same time, at the same place. I will not be here, but Meredith will, and she'll be joined by one of our partners. I believe it's Anderson Ellis, who people, if you've been watching all of them, which I assume everyone has, are familiar with Anderson. If you've got any comments, make sure you put them in there. We haven't seen them while we've been doing the presentation, but we'll be happy to respond as we're able to any comments. And just want to say thank you guys. The next presentation will be on nonprofits, which will be a little bit different, but we look forward to seeing you all again next week.